So, hello, everyone. Good morning. Thank you for joining us. My name is Nusayba Mubarak, and I'm the Government Relations Manager with the Institute for Middle East Understanding, IMEU. Thank you for joining us this morning for a brief yet critical discussion. In this moment, we're witnessing global attention on an unfolding genocide against Palestinians in the Gaza Strip. And as witnesses, we carry a responsibility, especially as Americans, with US weapons being used by Israel in this genocide. We carry an even greater responsibility. Last Friday, the International Court of Justice ordered provisional measures against Israel to prevent genocide under Article 2 of the Genocide Convention, including the killing of Palestinians in Gaza. That same afternoon, the first hearing in a landmark lawsuit in a US District Court was held, initiated by the Center for Constitutional Rights against President Biden for complicity and failure to prevent genocide. Today, we'll hear from Zaha Hassan, a human rights attorney and former senior legal advisor to the Palestinian negotiating team, and Katie Gallagher, who is a senior staff attorney at the Center for Constitutional Rights. She works on universal jurisdiction and international criminal law cases involving US and foreign officials and torture and other war crimes. And she is one of the attorneys in the lawsuit charging President Biden with failure to prevent genocide. And also joining us is Ahmed Abofoul, international lawyer and legal researcher and advocacy officer at Al-Haq. So thank you again for joining us. We really appreciate you coming here today. And just a little bit of background on IMEU. The Institute for Middle East Understanding is hosting today's webinar. IMEU provides expert analyses and information to congressional staff to better inform US policy on Palestinian-Israeli issues. So please do reach out to us if we can help provide your office with any informational needs. And just a quick logistical announcement. Please submit your questions in the Q&A as they come up for you. And if you submitted your question earlier during registration, we'll do our best to answer it. But please feel free to reshare your questions in the Q&A. And please note that we've enabled the anonymous Q&A setting for this webinar, and we won't use any names in asking or responding to your questions. We are recording this webinar, and we'll share the recording with congressional staff afterward. So again, today we'll be discussing two huge court cases, one in the International Court of Justice petitioned by South Africa, and the other in the US District Court in California brought by CCR, charging President Biden, Secretary of State Antony Blinken, and Secretary of Defense Lloyd with complicity and failure to prevent genocide. So we're going to just dive right in, beginning internationally and then moving to the federal case and what that means for the United States and our elected officials. So the International Court of Justice is the principal judicial organ of the UN that addresses legal questions and disputes between states, unlike the ICC, the International Criminal Court, which handles claims against individuals. And since Israel signed onto the UN Genocide Convention, and every state that ratified the convention has the legal authority and obligation to hold Israel accountable, including the United States, which adopted the convention in 1988, 40 years later. As we know, South Africans who ended their apartheid 30 years ago have taken the lead. And on Friday, last Friday, the ICJ announced provisional measures against Israel. And the American jurist and president of the ICJ read the ruling that South Africa's allegations of genocide against Israel are plausible. The court ordered Israel to stop harming and killing Palestinians, to allow aid into Gaza, to punish any incitement to genocide, and it ordered Israel to submit a report on steps taken within a month. Of course, we know that Israeli Prime Minister Benjamin Netanyahu and the Israeli government responded by saying that they will not comply and they will continue the war on Gaza. So today we'll hear from our experts on the ICJ case and the US lawsuit. Thank you so much for joining us, Katie Gallagher, Zaha Hassan, and Ahmed Abofoul. The first question is for Zaha Hassan. Zaha, what's your take on the court's decision? Can you walk us through the significance and the consequences of the ICJ's provisional measures?
Yeah, I mean, it was really, first of all, thank you, IMEU, thank you, Nusayba, for having me. I appreciate it. And thanks to everyone who is participating in this webinar. It's as I said, it's a really important case. You don't see state to state complaints based on the Genocide Convention and its application very often. And you don't see Israel brought before international fora in this way as a state. So this was significant on a number of levels. Also was significant because it was South Africa doing the initiation of this case, a country that has had historical experience with racial discrimination and genocidal acts. And so just in terms of the optics, this was a huge case. And now, just to be clear, this case, as you noted, you say, but correctly, it wasn't a decision on the merits. Basically, what the court was asked to do in this preliminary hearing was to decide whether or not there was a plausible case that acts were committed with intent, genocidal intent that fall under the Genocide Convention. And some of those acts were actual commission acts towards commission of genocide, like, as you noted, killing members of a group because they are a member of a protected group, and the court found Palestinians are a protected group, and that there was a plausible case that they were being targeted as such. And it also found that there was a plausible case of incitement to genocide as well. So, these are, again, preliminary rulings, but finding that, that the court had jurisdiction to hear this matter, and that there was a plausible case for finding the Genocide Convention applicable here because of really the mountain of factual evidence that was submitted submitted in the South African filing, as well as a lot of really damning genocidal statements that went to the intent of the Israeli officials responsible for prosecuting the campaign in Gaza. Now, every state has an obligation under the Genocide Convention. The signatories to the Genocide Convention, those countries that have ratified it, have a duty to prevent genocide. And so South Africa took up the matter because of its responsibility as a signatory to the convention, and the court found that it had, that was consistent with its obligation, and that it had standing basically to bring the case. So what are some of the provisional measures that the court talked about? Really, it noted 6 different provisional measures that it was ordering Israel. Actually, one of those really went to a call to Hamas, but I'll get to that in a second. But some of the things that the court ordered was for Israel to refrain from, actions under the Genocide Convention, including killing members of the group Palestinians, causing them serious bodily or mental harm, deliberately inflicting conditions calculated to bring about the physical destruction of the group in whole or in part, and imposing measures that would prevent births. I mean, the court listed out, these are basically in the Genocide Convention, but the court listed them out. The court also talked about preventing and punishing incitement to genocide and taking measures to provide humanitarian assistance to civilians in Gaza. And the court ordered Israel to preserve evidence and to take and to provide a report within a month about the measures that it's been taking. The court noted that IHL law is applicable in armed conflicts like what's taking place in Gaza, and it called for Hamas to release hostages, even though Hamas was not a party to this. And but the court did make that a part of its ruling. Now, this comes down to, of course, enforcement, whether or not these provisional measures will be enforced. As you noted, Nusayba, Israel has said that it isn't going to be complying with any ICJ ruling, but the ruling is legally binding on UN members, and it's binding on the signatories, obviously, of the convention. And the U.S. has taken the position that the ICJ rulings are legally binding, and in particular in matters involving provisional measures, that they are legally binding. It did so in the case between Ukraine and Russia. So, and I will note that the United States position was that the provisional measures that were ordered were consistent with what the U.S. had been calling for, which is more humanitarian aid and no targeting of civilians and such. Though the U.S. doesn't accept the premise of the case, it found that provisional measures were consistent with what it had been advocating for with Israel. But it's important to note that there was no call for a ceasefire. But if you read all of the provisional measures, there's no way that you can achieve what the court was calling for without a ceasefire. You can't get the massive humanitarian assistance in safely without a ceasefire. You can't repair the roads needed to transport all of that humanitarian assistance across Gaza without a ceasefire that allows for that to happen. You can't prevent the killing of civilians while bombs are going off in the way Israel's been prosecuting its campaign in Gaza. And I just want to note, the court didn't say, stop the indiscriminate killing of Palestinians. It said stop the killing, and to stop all these actions that are bringing about the destruction of Palestinian life in Gaza. And so you can't really achieve that without a ceasefire. But the U.S. hasn't. The U.S. noted that there wasn't a call for a ceasefire, and hasn't yet indicated that it will be pushing for a ceasefire. So the ball is in the court of the UN Security Council at this point. Algeria has advanced efforts in this regard to start to talk about how to enforce the ICJ ruling. So we'll have to wait and see where that goes from here. And I'll just stop there.
Thank you so much. You really left us at a cliffhanger there. Thank you, Zaha. It is definitely a ruling with major global significance, and I'd like to discuss it some more. But before we do that, and just, maybe dive into Algeria a little bit, first we want to, move the topic to the U.S. District Court case. And as we all know, the ICJ is actually going to be in the news again tomorrow with the Ukraine decision. So first, let's turn to Kate. Yesterday was a big day. Last night, there was a ruling by the judge in the lawsuit that you are working on. And the judge seems to have come to the same conclusion as the ICJ, that Israel's assault on Gaza is a plausible case of genocide. So what do you make of the court's decision? And can you tell us also what inspired the case and why CCR took the decision to charge President Biden, Blinken, and Austin on behalf of human rights organizations?
Sure. Thank you very much for having me. And maybe I'll go back to the filing of the case before I talk about the decision that we had yesterday. So already in October, right after starting on the 8th, even and the 9th, what we were hearing from Israeli officials was threats and promises, really action plans, unlike what we've even heard before. The Center for Constitutional Rights has been representing Palestinians in U.S. courts and before foreign courts and at the ICC for many years, working very closely with Palestinian human rights organizations, including Al-Haq, where Ahmed is working with the Palestinian Center for Human Rights, with El Mizan, with Defense for Children International Palestine, with Adamir. So we've had some experience with Israeli violations of international law over these many years, be it crimes against humanity or war crimes. But what we were hearing with the announcement of the total siege of Gaza from the Minister of Defense on October 9th, where he promised no food, no fuel, no electricity, no water, where the Minister of Electricity promised to implement this plan, where the president said the emphasis is on destruction, not accuracy, where the prime minister said Gaza will never be like it was before. These were statements that were statements of genocide. And what we saw in terms of the policies that were being carried out on the ground with the implementation of the total siege, the so-called evacuation order of 1.7 million people, and the bombardment from air, sea, and land of the entire population, we saw underlying acts of genocide. So by October 18th, CCR put out an emergency briefing paper that did an analysis of the facts and the law on genocide, warning that there was an unfolding genocide and highlighting the duty to prevent genocide. The Genocide Convention is unique because of the absolute severity of the crime here, the destruction of a people in whole or in part, that it places an obligation on all states to do what they can at the very instant there is a, quote, serious risk of genocide. And we had that through the statements and actions of Israeli officials. So on October 18th, we sent to President Biden, to Secretary of State Blinken, to the US Ambassador to the UN, to various UN officials, including the Special Rapporteur on the Prevention of Genocide. We sent them our 40-plus page briefing paper and called on all of them to take action. And instead, what we saw were more promises by the United States to send whatever Israel needed to carry out its plan against the Palestinian population on Gaza. We saw weapons deliveries expedited. We saw ceasefire resolutions at the UN vetoed, and we saw multiple trips by the most senior US officials to Israel, again, promising whatever you need, we will provide it. So seeing that there was no heeding of the warning and no implementation of the duty to prevent, we saw that we needed to litigate this. And litigating issues around Israel and on behalf of Palestinians in US courts has been something we have tried before and have lost in court under various doctrines. And we'll talk briefly about the political question doctrine, but we felt in this instance, the crimes and the harms were so severe that we needed to file a case. So on November 13th, working with Palestinian organizations like Al-Haq and Defense for Children International Palestine. And I would note here again what I think everyone knows at this point, that half the population in Gaza is under 18, and that more than half of the people who've been killed in this assault are children and women. So DCI Palestine and Al-Haq were our two organizational plaintiffs. It was very difficult at the point we were putting the case together to have access to anyone in Gaza because of the continual electricity outages and the communication blackouts that Israel is imposing. But we have 3 plaintiffs from Gaza, and then we have 5 Palestinian American plaintiffs. And so we put together a 2-count case, failure to prevent genocide and complicity in genocide, and laid out over the course of 85 pages the case of genocide committed by Israel and all the ways that the United States, with these 3 senior officials, have failed to prevent and instead have furthered or aided and abetted genocide. We asked the court to do 2 things: to declare, give us a declaratory judgment, declare what the law is, and that the United States is in violation of the laws regarding genocide. And we also sought a preliminary injunction, which is very similar to the provisional measures at the International Court of Justice. And that included to enjoin the United States, to make the United States stop sending weapons to Israel that are being used for the purposes of carrying out genocide. This was not a wholesale request to cut off all military aid, but to do what the jurisprudence of the ICJ on duty to prevent requires, and that is exercise your due diligence to see how whatever support you are giving to a state that is at risk of committing or is actually committing genocide, to look and see how are these weapons being used. And according to public reporting, the vast majority of the weapons being used against the Palestinian population in Gaza at this moment are coming from the United States, including in expedited deliveries since October 8th and up to and including into late December, if not into the new year. So these are US supplied weapons where no due diligence is occurring. In fact, the opposite. The United States officials have repeatedly said that there are no conditions on how weapons are being sent, that there are, quote, no red lines for how Israel uses these weapons. So in a nutshell, that is what we put together in the case. It was supported by a declaration put in already in early November by genocide expert William Shabas, who found, again, already in early November, that the United States was in breach of its obligation, its duty to prevent genocide. We also had, when we first filed, 3 genocide and Holocaust studies experts saying that everything they were seeing in this case was what you see in a genocide. We've heard the expression textbook case of genocide, and unfortunately, the elements are all here. And over the course of the briefing in this case, the United States never really pushed back on the fact that there is a genocide. Rather, they said the court can't stop us to do what we are doing, even if there is, that this is totally within the purview of the executive branch to decide to give what they term, foreign aid or military support, what we see as support for genocide. We also included, and I really want to highlight this, declarations from our plaintiffs over the course of the litigation, detailing the harms that their families were suffering on the ground in Gaza because of the genocidal acts, and also the harms that they are suffering, even those who are outside of Gaza, because of the serious mental harm, the concern, the guilt that flows, the fear every day of knowing, why is it that there was not a check mark on my WhatsApp message or my Signal message, because they don't know if their family members are still alive. So we put a lot of the truth of what Palestinians and Palestinian Americans are enduring in these now 4 months into the declarations that the judge also read. And we also, in our last round of briefing, had an expert declaration by former State Department official Josh Paul, which documented some of the weapons that are being used and came to the conclusion, in a nutshell, I'm paraphrasing here, but essentially said that this genocide could not be happening but for US support and US weapons. So that is the legal and factual background in this case. And we had our hearing, as you mentioned, on Friday, and things really did come together in very strange ways, with the ICJ judgment being announced just days before. So we woke up at 4 a.m. In Oakland before we went into court to watch the delivery of that judgment. But another thing that happened just days before our hearing was that the judge granted our request to have witnesses, live witnesses in the courtroom, testifying to the irreparable harm, the irreparable harm to the facts on the ground in Gaza, in support of our motion for a preliminary injunction. So on Friday, we had first the legal argument where essentially we said that it cannot be and it must not be allowed to be a policy decision for the President of the United States to support a genocide. That is unlawful, and this is fundamentally different from the acts that are protected from judicial review through case law around ministerial decisions or policy preferences of whether or not, let's say, to send foreign aid to a government. That choice disappears when we're talking about unlawful conduct, that no one, including the President of the United States, is above the law. We'll get to the decision in a moment, but we had the legal part, and then we had what I would just call 3.5 hours of extraordinary testimony that really I would implore everyone to watch. The link to our hearing, it's on the court's official website. It was recorded by the court, and it's one of the cases that they've put up permanently on their website, so you can watch the 4-hour hearing in its entirety. But we had our first plaintiff was Dr. Omar Najjar calling in from Gaza, from the hospital in Rafah, and he testified to the facts and the reality on the ground, in just painful but critical testimony. And then we had the two Palestinian human rights organizations. I'll let Ahmed speak about that, maybe both Al-Haq and then DCI Palestine calling in from Ramallah. And then we had a number of our Palestinian American plaintiffs testifying and saying things like explaining how their families got to Gaza if they were displaced in the Nakba, if they were ethnically cleansed, that was said in the Nakba. We had descriptions of the suffering that they are enduring, the reality for their family, but we really had a history of what has been endured by Palestinians through the decades since the Nakba, through the occupation, through the military assaults on Gaza, through the blockade on Gaza that has already gone on for 17 years, and ultimately the current genocide. So that testimony was heard, was recorded, and the judge said, "I see you and I hear you." So that was all very, very powerful, which brings us to what we received yesterday, and that's the decision by the judge. And indeed, yes, he made some very strong findings. And I think that this is, again, probably unprecedented to see in a decision by a US federal court judge. He makes reference to the ICJ judgment, and he says, "The undisputed evidence before this court comports with the findings of the ICJ and indicates that the current treatment of the Palestinians in the Gaza Strip by the Israeli military may plausibly constitute a genocide in violation of international law." Continues. "Both the uncontroverted testimony of the plaintiffs and the expert opinion proffered at the hearing on these motions, as well as statements made by various officers of the Israeli government, indicate that the ongoing military siege in Gaza is intended to eradicate a whole people and therefore plausibly falls within the international prohibition against genocide. It is every individual's obligation to confront the current siege in Gaza." So those were very, very powerful findings. And I think just on the siege, it's very important to remember as we talk about the quote unquote humanitarian crisis, this is not a natural disaster. This quote unquote humanitarian crisis is an underlying act of genocide. It is a result of the intentions of the Israeli government, with support from too many states, to put in place the conditions of life intended to destroy the Palestinian population in Gaza in whole or in part. It is the result of those action plans to deny access to food, to water, to electricity, to decimate the healthcare system. So all of this is actually following on the intentions of the Israeli government. And I'll just come to the conclusion of his decision, and then I'll highlight the legal conclusions. He says, there are rare cases in which the preferred outcome is inaccessible to the court. This is one of those cases. I'll talk about his precedent in a second. Yet, as the ICJ has found, it is plausible that Israel's conduct amounts to genocide. This court implores defendants, meaning Blinken, Biden, and Austin, to examine the results of the unflagging support of the military siege against the Palestinians in Gaza. So effectively, he's acknowledging that the United States is aiding and abetting the genocide in Gaza. The legal conclusion, unfortunately, is not in line with all of what I just read. The judge dismissed the case, finding that it did fall within the political question doctrine. He relied on past precedent, including the case of Corey v. Caterpillar, brought on behalf of the family of Rachel Corey and 5 Palestinian families against the company Caterpillar, which provided Israeli forces with militarized bulldozers. And in that case, the Court of Appeals above this judge had found that foreign policy decisions around supplying something like militarized bulldozers was something that could not be reviewed by a court, that this was a foreign policy decision. We tried to distinguish this case, and I believe there is a legal distinction when here we have not a ministerial decision around rubber stamping or approving the use of foreign military financing for a direct commercial sale, but where we have the President of the United States knowing that there is an ongoing genocide and continuing to provide the, quote, unflagging support to Israel. So the decision just came in yesterday, but we will be pursuing whatever legal options we might find appropriate here with the plaintiffs to continue to try and stop the genocide. Now, I just want to highlight, especially with the audience that we have here, the executive is one branch, the judiciary, of course, is another, and then we have Congress. There is a lot that Congress can do to achieve what we were trying to achieve through the preliminary injunction by putting in place the kind of due diligence and vetting of what US weapons are going to Israel and how they are being used. And if they are being used to further a genocide, which is of course unlawful, we have a court, a US court, we have the ICJ. Congress should put in place those blocks so that whether it's bunker busting bombs or whether it's JDAMs or whether it's the more munitions and shell casings that Israel needs to continue this genocide, there is a legal obligation in which the ICJ noted on all member states of the Genocide Convention to exercise due diligence and to take measures to prevent and to stop genocide. So that is something that Congress can and we hope will be doing immediately. Thank you.
Thank you so much, Katie. We really appreciate you being here and for your work on this case. We really appreciate you, and that's a lot of very helpful information. And you know, the judge's ruling is absolutely unprecedented, and it's very interesting to read his judgment. So my next question is for Ahmed, and the question is two questions. First, why now? Why has the Genocide Convention not been invoked before for the Palestinian people, considering 75 years have passed since the Nakba, the first massacres or genocide in 1948? And could the Genocide Convention not have been invoked before pre-October 8th? So that's the first part. The other one is, you know, it's very interesting to have read some of your work, and you've written extensively about the need for the ICC to prosecute Israeli officials, the International Criminal Court. So can you share a little bit more about that as well?
Yes, thank you very much for having me. Can you hear me well? Oh, perfect. Okay. Thank you very much for organizing this and for having me. Well, the answer to your first question is symbol. As you rightly pointed out, many would argue that 1948, the Nakba, the ethnic cleansing of Palestinians from their ancestral homeland, would amount to genocide, and I would agree with that. The only problem is that the Genocide Convention was not drafted yet, and the concept of genocide hadn't crystallized yet as a concept within a convention that is punishable. That's why it was not called genocide. But as a matter of fact, it was genocide. The reason that we didn't have any allegations of genocide since 1948 is we didn't have something at this large scale. As a matter of fact, there was one incident that was described as genocide, and that is the Sabra and Shatila massacre, who's responsible for was at the time Sharon, who was Minister of Defense. And this is the only incident in the records of the UN that is described as acts of genocide. So it did happen after 1948, but it was never litigated before the International Court of Justice. Now, as the other speakers, my colleagues, pointed out, this is only a preliminary ruling on the provisional measures. The court does not have to decide on the merits, so it remains a question whether the court will have the same conclusion or not. But what's important at this stage that there is plausible case for genocide. And if you allow me, before moving, I think I've read some of the questions, and I think there's a lot of oversimplification of this ruling. Unfortunately, politicians, including U.S. politicians, have been providing a distorted interpretation of this ruling, and intentionally so. I don't think they don't know. They know very well. They have advisors who advise them. For example, the whole allegation that the court did not call for a ceasefire is quite disingenuous, because the court cannot call for a ceasefire. The term ceasefire is a political one, it's not a legal one. The court have never called in any genocide case for this word a ceasefire. What the court would call for, and as a matter of fact, the only case where it called of suspension of hostilities or stopping military operation, it was the case between Russia and Ukraine. The reason to that is that Ukraine took Russia to court because of a dispute in the interpretation of the convention. That is, Russia has claimed that Ukraine is committing genocide to justify its aggression. So when the court was assessing the allegation of genocide, it was about the military operation per se. And that's why it had to say that it had to order Russia to suspend or to stop its military operation. In Myanmar, the court did not order, for example, suspension of hostilities. It ordered Myanmar to prevent the commission of all genocidal acts, and it listed them as it did in this case. In Bosnia and the Serbian genocide, the same thing. So the whole notion of, and I heard, the U.S. representative at the United Nations Security Council saying, let's talk about what the court didn't say. The court didn't say ceasefire. Well, because the court cannot say ceasefire. This is not a legal term. The court can order the suspension of hostilities, and that is when the court can rule on both parties to the armed conflict, like in Ukraine and Russia. Here, it's a different situation, and it's not about military operation itself. It's about the genocidal acts. That's why it's a different case, and it's a very, I think, regrettable that politicians recourse to such disingenuous way of portraying a court ruling. The public, the American public, also deserve to know the truth about this ruling and what the court has ruled. That's why I think it's very important to speak to Congress members and their staff about this topic, because I think this needed to be clarified. So what the court has ordered, in effect, and I agree with that, is actually a ceasefire. So if the court has ordered Israel to prevent the commission of genocidal acts and listed them, so technically the court said Israel has to stop the killing, to stop creating conditions calculated to bring the existence, the destruction of the Palestinian population, and ordered the list of the provisional measures, including, including the immediate, to ensure that the military, and this was the second provisional measure, the military does not commit any of the listed acts. So now the court told Israel, do not kill, do not create conditions calculated to bring the destruction of the Palestinian population, among other things, and then report to me after a month. What Israel is going to report? Until now, we have over 1,000 that have been killed since that ruling. So that's why you have statements from Israeli officials that we will not abide by the ruling because they will not stop the killing. So I just wanted to clarify that. The court ordered Israel to prevent the genocidal acts, and in a separate order, ordered Israel to ensure that its military is not committing any of those acts. It also ordered Israel to punish the public and direct incitement for genocide. That is something we haven't seen. And as a matter of fact, since the court ruling, Israeli officials continue to issue such statements, including government members, cabinet members, who called for once again dropping a nuclear bomb on the Gaza Strip. The court also was unequivocal of the need to allow humanitarian aid for the civilian population, and it was very specific that humanitarian assistance must be allowed to address the conditions that are faced by the Palestinians, and this is connected to a genocidal act, creating conditions to bring about the destruction of the protected group. So Israel, when reporting to the court, it has to prove, it has to tell the court how it met this obligation, how it allowed this humanitarian aid that addressed the conditions of Palestinians in Gaza. Of course, this did not happen, and it doesn't seem that there is intention for that to happen. One important thing also, the call from the court and the provision measure on the preservation of evidence. And here, let me maybe speak a bit about the work of Al-Haq. Al-Haq is the oldest Palestinian human rights organization. It's the oldest in Palestine, the oldest in the region. We've been in this business for over 45 years, since 1979. And since our establishment, this was the first time that we had to announce that we're unable to cover the situation in Gaza. If history taught us something, in such situations when there is no human rights defenders documenting the crimes and the violations that are being committed, usually the perpetrators are emboldened and encouraged to commit more crimes. And we've seen this. We've seen Israeli soldiers bragging about committing crimes because they feel untouchable. Because in all honesty, the US and other allies of Israel has ensured that Israel is never held accountable and Israeli criminals are never held accountable. So they feel above the law. They feel the impunity that was ensured for decades. As a matter of fact, the Israeli apartheid and settler colonial regime is premised on a promise of impunity to its soldiers. So any form of accountability will shake this system. And that's why you have Israeli reactions that are so extreme to any justice mechanism. So, for example, when the Palestinians went to the ICC and referred the situation to the ICC, and the ICC started an investigation, Netanyahu said this is pure anti-Semitism. When the Palestinians went to the International Court of Justice, the Israeli leaders said this is diplomatic terror. So, in a way, with all due respect, our American colleagues want to convince us that this is a beacon of democracy and, quote unquote, the only democracy in the Middle East. But in the same time, this democracy refuses to go to court. In what word? I don't think this is reasonable. One of the most important pillars in any democracy is the rule of law. And this actually was the motivation behind this case, that we trust the rule of law. We trust that such questions must be litigated. And that's why we took this case to court. And I think the fact that the judge dismissed the case on the technicality on the jurisdiction issue, it doesn't mean that this was not, I think, a victory, because the judge acknowledged that genocide is being committed. And basically what he was saying, that his hands are tied. He just doesn't have the authority to rule on such matter, but in fact, he acknowledged that genocide is being committed. Therefore, the US is not only in violation of its obligations under the Genocide Convention, but also under US law. And I think it's quite regrettable that the U.S. continues to provide Israel with weapons that are killing Palestinians on a daily basis. The situation in Gaza is unparalleled and unprecedented. We have not seen this amount of destruction and disregard to human life since World War II. And I think the United Nations even spoke about that. Part of my testimony, since you asked about this, I had the opportunity to testify in a way in three hats. So I was testifying on behalf of Al-Haq as a member of Al-Haq who was also affected. So I had to show the harm that Al-Haq has endured as an organization and how our work has been affected. But I was also testifying as an expert in international law. And the third hat, because I was affected myself. I lost over 60 members of my family from my father's side, and over 22 from my mother's side, including her aunt, who's 90 years old and remains missing. And this has affected us, not only as individuals, but the work of the organization. On the ICC, I think the ICC is an important mechanism, and as known, the ICC was never established to prosecute all alleged crimes in any situation. It cannot do that, and it was not established to do that. The court was established to prosecute those responsible for the most serious crimes. So in the situation in Palestine, the court has a responsibility and an obligation to prosecute such crimes. There is an open investigation since 3rd of March 2021. Our official position as Al-Haq that we believe it's long overdue for the prosecutor of the International Criminal Court to start issuing arrest warrants. We believe that he has enough evidence to start issuing arrest warrants, and not only for those responsible for war crimes, but also crimes against humanity and possibly genocide. It's important to note that it's a different standard of proof in a criminal case at the International Criminal Court, and the burden of proof is perhaps more difficult, but certain crimes are definitely, I think, within the jurisdiction of the court, and there's enough evidence. On the top of that list would be, for example, Israel's colonial settlement enterprise, which the U.S. itself acknowledges that these are legal, and there is international consensus about the illegality of settlements, and it amounts to a clear-cut war crime where all the information needed to prove such a case is available in the public domain. So unfortunately, the U.S. has not shown support to either of those mechanisms, not the ICJ, not the ICC, and it's quite unfortunate because the U.S. Proclaims and portrays itself as a country that respects the rule of law and a democracy. And we believe, as I said, one of the main pillars of any functioning democracy is the rule of law. And we believe that civilized nations should always recourse to law, and that's what the Palestinians are trying to do. The question is how the U.S. is accepting that its ally, self-proclaimed and U.S. promoted as the only democracy in the Middle East, refuses to go to court in any situation, refuses the rule of law. I think that's the question that the American politicians and leaders should answer, because as we stressed in that court in Auckland, in the U.S., the three defendants, the President of the United States, President Joe Biden, the Secretary of State, Blinken, and the Secretary of Defense, Austin, three of them, they have blood of Palestinian children on their hands, and they're guilty of their complicity and failure to prevent the genocide in Gaza. Thank you.
Thank you very much, Ahmed. That's very helpful. And we're really looking forward to hopefully seeing that ICC case. I think that would garner more pressure and attention on U.S. complicity in this matter. Now, I have a question for Zaha, and I'm trying to be mindful of time, and I'd like to get a question from an answer from each of the panelists as well. So we have one question from the audience that is, am I correct in my understanding that ceasefire requires a negotiation with Hamas? It seems like the court, and of course they're referring to the ICJ, specifically asked Israel to stop its acts of genocide independently of any negotiations. Isn't this better than asking Israel to negotiate a ceasefire? So that's one question. And then the second is, Zaha mentioned Algeria has advanced efforts. So I'd like to know what actions can be taken to stop the genocide of Palestinians if Israel continues to dismiss international law and court rulings. What mechanisms can we explore beyond legal proceedings to address the implications of genocide? And so we'll start with Zaha, and then to Katie, and then Ahmed.
I'll be very brief so we can get everybody in, since we are running out of time. So on the ceasefire, yeah, it takes two to, stop the fighting. And so that might have been the wisdom of the court as well, and not addressing this issue directly. And even though South Africa had put that in their request, but the court did reference IHL law, and even though Hamas wasn't a party to the case, mentioned and called for Hamas to release the hostages. For Hamas's part, it's looking for a permanent ceasefire. So I don't think there would be much, much of an issue on Hamas's side with respect to getting to a permanent ceasefire. The holdup has been that the discussion has been around temporary cessation of hostilities rather than a permanent ceasefire, which is what Hamas is looking for. On this question of where do we go from here with Algeria's efforts, I think we don't know yet what the position that the U.S. is going to take now that we have an ICJ ruling. It certainly has to give the U.S. pause that we now have this ICJ ruling, and so it has to think about the idea of vetoing another resolution if we get to the point where we have another Security Council resolution calling for a ceasefire. But let's suppose that the U.S. opposes and it uses its veto power again to block such a resolution. There is this opportunity in the General Assembly and this Uniting for Peace resolution that the General Assembly can utilize when a permanent member of the Security Council is blocking a resolution. So, but again, it comes back to enforcement, and really the only party that has the ability to change Israel's behavior is the United States. And there are Israeli former military officials who have been quoted as saying that as soon as the U.S. dries up the tap, turns off the tap, and stops sending munitions to Israel, there's no way that Israel can continue to prosecute its campaign in Gaza. So the U.S. is critical. I just want to note that the U.S. is a signatory to the ICJ, to the Genocide Convention, and it has a duty to prevent genocide. The U.S. though has a reservation in the Genocide Convention where it says that it has to consent to be brought before the ICJ under the Genocide Convention. So this, there is this interest by some in bringing the U.S. before the ICJ as well for complicity. It's a question, and maybe Katie and Ahmed can weigh in on whether or not a reservation like that really undermines the entire convention is enforceable. It hasn't been litigated to my knowledge, so that would be a question. But the U.S. also has its own obligations in U.S. federal statute about preventing genocide, and they have a whole of government approach that they've developed around preventing mass atrocities and preventing genocide. And to my knowledge, the U.S. hasn't made its own legal assessment, or if it has, it hasn't shared it and hasn't taken action on it. And I think something that others can do, particularly civil societies, to put some pressure on their elected officials, members of Congress, to call out the U.S. for not doing that, because once the U.S. makes a legal assessment like that, then it has to take action, and that's what we need to see. And I'll stop there.
Thank you very much. Katie?
Yeah, just briefly, I think at this point, the legal conclusions are there. The United States is clearly on notice that its actions are in violations of both international and domestic law. And so it needs to take action. And I hope between the decision from the ICJ and a federal court judge yesterday, it does, but I don't have faith that it will. But I want to pick up on what Zaha said about civil society. I mean, one of the things that was most inspiring to me on Friday when we were in the hearing in Oakland, and we would look out, the hearing went so long that we had 2 breaks, and to see the massive turnout on the streets of Oakland, literally shutting down 3 streets, having a massive, we charge Biden with genocide in front of the courthouse. We've had resolutions passed at the city level in Oakland and San Francisco, denouncing the genocide and calling for an end of support for it. So I think we need to see more of this from civil society, from constituents calling their members of Congress, and we need to see really Congress stepping in this space to stop this flow of weapons, to turn off that tap. Congress has a role to play, and it really needs to. And needs to make it clear to the Biden administration, especially in this election year, the consequence of violating clear law. And I think there's a global consequence here. We had a number of amicus briefs come into our case, one of which was from 77 human rights, civil society, bar associations around the world. And they warned of the erosion of rights globally if the United States is not held to account for its breaches of international law. So I think going to Zaha's point of what the US might do at the Security Council with an ICJ judgment, when there is the Ukraine v. Russia case, when there is Gambia v. Myanmar, when we've seen the United States previously support conclusions by the International Court of Justice and their efforts to put in place measures to stop a genocide. If the United States does a 180 on that now, it's terrifying to think of the consequences for all places. Certainly, it's terrifying to think of the consequences for Gaza. So I think the United States needs to be thinking more broadly about the overall, international legal order that it speaks of so often. And just lastly, I see that there is a question here about whether it's Netanyahu or whether it's the state of Israel. I think that what we've seen over these past 4 months is from top to bottom across the entire Israeli government, there has been support for the genocide in Gaza, and that unfortunately we're seeing support across too much of the population in Israel as well. I do think that there is individual criminal responsibility that needs to be assessed. And as Ahmed pointed out, there's an international criminal court for that. There is also universal jurisdiction, because genocide is a crime that is recognized as a violation of customary international law. It is one that all states can take measures to prosecute. So whether it may be in the current moment that there won't be a case against Netanyahu or the Minister of Defense or the Minister of Energy or the Minister of Foreign Affairs or battalion commanders, I do think that we will be seeing many efforts of accountability playing out. And that also includes, and I just want to make one last mention, the companies that are now on notice because of the ICJ judgment and the US court judgment, if they weren't before, which they should have been. And those companies also have obligations to not be furthering a genocide by continuing to sell and supply weapons that are being used to kill Palestinians every day.
Thank you very much. And finally, last but not least, Ahmed.
Yes, and well, first of all, I will try to touch upon all questions that I see very fast. The last question on whether the U.S. administration can keep saying this is meritless and baseless. The U.S. can do whatever it wants. It can keep saying that, but it wouldn't make it true. Now we have a ruling from the ICJ that is saying otherwise. And I think what is at stake here is not only, the very existence of the Palestinian people, but also the whole body of international law and whatever left of credibility of this law and the reputation of the U.S. So I think the U.S. needs to realize at some point that its approach toward Israel is not only destroying its reputation as it proclaimed to be a beacon of democracy and supporter of democracies around the world, but also it benefits other geopolitical actors. Our part of the world, when it sees that the U.S. is supporting Israel in its genocide and not holding Israel to account, they will sympathize with other parts of the world. And this is something I think that is very negative, and the U.S. need to pay attention to it. I think the current ruling we have, it didn't only destroy the U.S. allegations that this is meritless and baseless, but also another thing that the U.S. has been parroting for a very long time since this started, which is that Israel is acting in self-defense. If you read the ruling of provisional measures, self-defense is not mentioned. It's only mentioned once, a quote from Israel. And why the court did that? Because the court answered this question back in 2004. Israel does not have the right to self-defense in this particular situation. The right to self-defense is regulated under Article 51 of the United Nations Charter, and this is a right inferred for states against other states. This is not the situation. Israel is not attacked by another state, and even if there is discussion whether a state can invoke this right when it's attacked by an armed group, there's absolutely no doubt that an occupying power, which naturally positioned itself as the aggressor, cannot invoke self-defense against people it occupies. This is what the court said in 2004, and it said because Israel argued then that building the apartheid wall was in self-defense. Even that, Israel argues everything is in self-defense, and the court said that the invoking the rights of defense under Article 51 is irrelevant to this case because of the occupation. I don't need to remind you, this is the longest occupation in modern history. The fact that the U.S. allowed this occupation to last this long, I think is a stain on us all and on U.S. foreign policy, and history will not judge the U.S. Kindly for its support of genocide. This is a record of history, and Palestinians will not forget or forgive that they were massacred on live TV by American weapons. The question on whether this is the disproportionate response from Netanyahu government, I think this is also an oversimplification. It's not about Netanyahu. It's not about individuals. It's not like before Netanyahu, the situation was better. Let me just stress, Israel's governing ideology, Zionism, is inherently genocidal. The same genocidal statements we heard, and they are documented in history from the early leaders of Zionism, from Ben-Gurion to Jabotinsky to Herzl and many more. They all spoke about the fact that the Palestinian existence as indigenous in their land is an obstacle to the settler colonial project because it's built upon the notion of acquiring more land with less Palestinians. That's why from the very beginning, it was clear for us, this is about pushing the Palestinians out of the Palestinian geography, out of the Gaza Strip. Because this is not because we're so smart and we analyzed it. No, because the Israelis have been saying this for decades. But the problem, with all due respect, the Americans don't listen. Or as Carter once asked by Amy Goodman, don't the American people know? He said they don't want to know. Or the American officials, he said they don't want to know. And I think for decades, the Americans have been hearing about the Palestinians, but not listening to them, not hearing from them. And only through the lens of Israel's colonial narrative, always dehumanizing the Palestinians as irrational, quote unquote, don't miss an opportunity to miss an opportunity, we can't reach peace with them, etc. And some US officials seem to forget that in the Oslo Accord, the Palestinians even agreed to only 22% of historical Palestine. I don't believe any nation in the history of mankind made such compromise for a better future for their children and the Israeli children. It's also important to note that Israel has been preventing the Palestinians from having elections. What did the U.S. do about that? Nothing. The U.S. now talking about reviving the Palestinian Authority, which is not democratically elected, which is corrupt. But the U.S. is okay with it as long as it doesn't produce a new leadership in Palestine. So this is a big question to the U.S. Don't the Palestinians deserve democracy? Why the U.S. doesn't pressure its best ally to allow elections in the occupied Palestinian territories? Yeah, I think I answered. Oh, there's a question on UNRWA. Well, and whether there is a link. I don't know if there is a link or not. What I know that Israel has a history of pathologically lying. In the past 3 days alone, first we heard that there is 13 staff. I think I read something today that it was reduced to 6. Antony Blinken, Secretary of State himself, acknowledged that they haven't seen any evidence of that, and they relied on Israeli allegations. I would be very skeptical of any Israeli allegations, but I'm a lawyer. I respect the rule of law. I think there needs to be an investigation, and whoever is responsible must be held accountable. But to cut funding on the whole institution that provides supports not only to the people of Gaza, but refugees all over the world. I was born a refugee. I've never seen my homeland, and my family was ethnically cleansed from it. So UNRWA, it's not only about Gaza, it's about the whole Palestine. So when several officials describe this as a collective punishment, it is a collective punishment. And whether there is a connection to the ICJ, I think an important fact is that the ICJ ruling relied on UN statements, especially UNRWA statements, especially statements from Lazzarini himself. So I don't know if the U.S. If Israel didn't like that. The intention from Israel to destroy UNRWA, to end the so-called refugee question, to liquidate the Palestinian cause is not new. Israel has been attacking UNRWA for decades. So to pretend now that this comes in such timing because there is some sensibility in it, I would be very skeptical of that. Although we're very clear, there need to be an investigation, and there is nothing in the world, even if there was involvement of certain members, it doesn't justify collective punishment of a whole organization and millions of Palestinians who desperately need this aid. I conclude with that. I'm sure most of you know, but people in Gaza, especially in the north now, are eating grass because there's no food. In what world do we live in? And then the US cuts funding from an institution that barely manages to get this aid to the Palestinian. As I said, I think the history will not judge the US kindly and the Palestinians. And I think all the free people of the world will not forget or forgive that.
Thank you so much, Ahmed, and for addressing those questions from our audience. As we know, millions of refugees depend on UNRWA. More than 7 million visit. There are more than 7 million visits to the health clinics of UNRWA annually. So this is certainly a very terrifying moment. And thank you so much for addressing the questions. Thank you for joining us. Thank you to our speakers. Thank you for the audience for joining us today. It does sound like that we are reaching a point in history where international pressure is going to impact the US and US ties to Israel. And I think that this panel certainly showed that today. So thank you so much for joining. And for the audience, please share your feedback with us by responding to the 2-question survey. It's very important to us. We look forward to staying connected, and IMEU also has a weekly roundup of Palestine updates that we share with the Hill staff every Friday, and we just released this last week. To join that list, please email me. It's in the chat. It's nusayba@imeu.org. And for timely updates on the unfolding devastation in Gaza, follow IMEU's social accounts by clicking the link in the chat. And if you or your boss would like to schedule a meeting with us or to share more information, please also email me at nusayba@imeu.org. Thank you again so much to the panelists. Thank you to the audience for joining us, and have a great day.
Thank you.